State of San Andreas is now in session. The Honorable Justice Granny Noonan presiding.
Hello, dearie.
Hello.
Hello.
State of San Andreas versus Michael Francesco. Appeal will be heard now. Each side will have 15 minutes. Do not argue back and forth, dear. I will slap you with a golf club, okay?
She will.
What?
She'll have my protection if she does it. It's okay.
Be quiet, dear. This is an appellate court. You will be quiet or you will be held in contempt. Now, the state may make their case, dear. Go ahead.
Is this my 15 minutes now, Your Honor?
Yes, dear, but please speak up.
Yes, ma'am. The appeal here today is under these reasons. The trial judge wrongly stated that a 911 call from a local citizen is not deemed a reasonable suspicion that a crime has been committed. I'll quote, "One anonymous 911 call did not give enough reasonable suspicion for Mr. Francesco to be frisked and searched for just being at the apartment block. Therefore, the frisk and subsequent search were deemed illegal based on Terry versus Ohio with a lack of reasonable suspicion." I would like to, if I may, look at subsequent cases after Terry, which I'm not stating as case law, but as an example of the sliding rule that allows officers to fight crime, if that's okay with Your Honor.
You may allude to them, dear, but do not reference them directly. Thank you, dear.
Yes, ma'am. There's been cases in the past where the Supreme Court held that a stop was justified, even though the anonymous nature of the tip permitted no estimation of its reliability, which seems to fit. There's also another where the police were allowed to set up a sobriety checkpoint, which stopped a lot of cars, which resulted in 2 arrests for driving under the influence. These stops were made without reference to any observations of any particular car. That is, the police had no suspicion, reasonable or otherwise, concerning any individual who was stopped. Rather, the police stopped all cars on the blockaded road. The Supreme Court returned to its balancing of interests analysis to justify this practice. Given the magnitude of drunken driving problems and the slight nature of intrusion upon the privacy of those stopped, the Supreme Court found the stops at the checkpoint to be reasonable, despite the absence of individualized suspicion. This city has a gun and drug problem, which is why this case I used as an example. The officers in this case detained and frisked all citizens in that area, not just the defendant. Every person in the vicinity of the 911 call was detained and frisked, which revealed the crime itself: a Class 3 weapon on one individual and a Class 2 weapon found on the defendant. I mention these examples because courts hearing suppression motions based on Terry stops and frisks should defer to the police officers, because they have the knowledge, the expertise, and ultimately the responsibility for combating crime. Officers, as proven in evidence and testimony, had reasonable suspicion a crime had been committed due to the 911 call stating the exact location of the defendant and his friends. The officers, as is their right, are allowed to frisk individuals for their own safety when they have reasonable suspicion that they could be armed. The fact that the call itself stated a Class 3 weapon makes the response of the officers dangerous in nature. The defense themselves, in their rebuttal to this appeal, even stated in their Terry versus Ohio argument, and I'm quoting, "An officer may perform a frisk for weapons if they reasonably perceive a risk of safety of themselves and others." They also go on to state later on, and I'm quoting again, "A frisk under Terry is solely to determine whether there is a safety risk, not a tool to be abused by law enforcement to perform unreasonable searches for investigatory purposes." Now, this does seem quite contradictory. The Terry frisk was performed, and they did find a safety risk of 2 illegal weapons. Also, how could the frisk be to determine a safety risk without being an investigation? The judge also calls Terry vs. Ohio into question when it clearly states Nothing in the initial stages of the encounter serves to dispel the officer's reasonable fear for safety. The officer may conduct a carefully limited search of the outer clothing of the subject in an attempt to discover weapons, and that such a search is a reasonable search under the 14th Amendment, so that any weapon seized may be properly introduced into evidence. Another statement from Terry v. Ohio. The court, with only Justice Douglas dissenting, approved an on-the-street investigation by a police officer that involved patting down the subject of the investigation for weapons. The officers all stated in their testimonies that they completed the frisk search for their safety, which means they had reasonably perceived a risk to themselves due to the nature of the 911 call. For the defense and the judge to decide whether an officer in the line of duty does not have the right to perceive a risk for themselves cannot be allowed to stand. The officers are putting their lives on the line, and they have that right alone. A citizen of the city made a call to police through 911 stating a crime had been committed. If 911 calls are, in the eyes of a trial court, deemed not viable to a crime being committed, this will set a dangerous precedent for the citizens of this city who rely on 911s and the police for their safety. Moving to the comment of just being at the apartment block is also the judge stating an opinion of innocence, which was never brought up or said in court by the defendant. The officers clearly stated that the defendant was in the location of the 911 call, whether coming out of a building or not. No mention of him just being at the apartment block. This tantamounts to bias in the defendant's favor.
Dear, I am going to stop you right there, okay, dear? We are not going to get into judicial bias or anything else. This is about reasonable suspicion and whether or not the 911 phone call justifies a reasonable suspicion with a Terry stop, dear.
Yes,
anything else in regards to the judge, I do not want to listen to it, okay?
Yes, ma'am.
You may continue.
I am going to quote the judge, but not in the term of bias, Your Honor.
Go ahead, dear.
Also, in the explanation of the not guilty verdict, the judge deemed Elios testified on the stand that they never saw a weapon in any individual's hands, never saw anyone flee the area, and one officer saw Mr. Francesco walk out of an apartment and talk on the phone. This statement in the first part is saying that the officers not seeing a weapon in the hands of the defendant was needed to frisk. Seeing a Class 3 weapon in the hands of the defendant would be correct for probable cause, not reasonable suspicion. The second part of the statement is claiming guilty people always run. Thus, the defendant must be innocent because he did not run. The officers and defense have all stated if they saw the defendant or others fleeing from the area, ask the defendant or any parties if they had a weapon on them, check to see if any party was a convicted violent felon, or whether or not they had firearms licenses. To each they answered no. Would this not also deem that the guilty party was still in the area? Throughout the explanation in court of the verdict of the judge stating that Elios could not give any more evidence to warrant a frisk for the defendant, they did not need to. What the judge was asking for included seeing weapons in the defendant's hand. This would be for probable cause for arrest, not for frisk of officer safety, whilst investigating a legitimate call from a citizen of the city involving a crime of a Class 3 weapon. These officers, at risk to their own lives, answered a 911 call from a citizen, and there was a risk to life due to there being an illegal Class 3 weapon in the area. They found in that area the group mentioned, which included the defendant. Upon the stop and frisk investigation, 2 illegal weapons were found. The crime was there. The reported weapon was found. The officers used their right to frisk for safety and found those guilty of possessing illegal weapons, which the defendant was one. Thank you, Your Honor.
Is that all now, dear?
Yes, ma'am.
Okay. Mr. Hall, Mr. Hunt, you have 15 minutes, dear.
Excellent. Thank you. All right, Your Honor, I'd like to begin by going over sort of the facts of the case and really how they relate. So it wasn't alluded to at all, really, in the appellant's brief nor today in trial. Now, this all took place on October 27th. It was testified in court, and of course, the court found that officers had received a 911 call reporting a sighting of a Class 3 on Rub Street. Of course, the call was then responded to mainly by Officer Goldberg and several other officers that responded to the scene. Now, what they witnessed was a crowd of 6 people. Now, they also, of course, did see 2 vehicles on the scene, but mainly they saw a crowd of 6 people, including the defendant, standing on the grounds of an apartment. The officers approached the individuals, and it was specifically Officer Goldberg that gave them a command to stay where they were and that they were being detained. Officer Goldberg then testified to waiting for other officers to arrive on the scene, and then informed everyone in the group that they were going to be frisked. Now, from there, Officer Goldberg separated the defendant from the rest of the crowd and frisked the defendant. Of course, we later learned that in the course of that frisk, he did find an illegal firearm as well as a bottle of drugs. And that's at what point the defendant was placed under arrest for what he found. Now, I would like to address the case law of Terry v. Ohio. Now, Terry v. Ohio was both mentioned in the appellant's brief and trial today. Specifically, was brought up by them in the trial court, or the original trial, rather. Now, overall, Terry v. Ohio is applicable in this case, and it is the only case law that should be considered when a ruling is rendered. Overall, Terry v. Ohio is the only accepted case law in this state. Again, should be the only one that is considered in terms of weighing whether or not this search was lawful. Now, overall, what I alluded to in the respondent's brief is that Terry is a very restrictive case law. It doesn't give the police the power that most officers or even attorneys believe that it does. Overall, an officer can perform a frisk. Well, let me back up, I suppose. I'm going to go over the sort of the background of what Terry is. Overall, it was a case in which the officer that...
Do you need a minute to collect your thoughts, dear?
That's all right, Your Honor. I'll continue. Overall, Terry, his background is pretty simple. An officer was patrolling an area he'd been patrolling for years. He observed 2 individuals that were acting suspicious. They were walking up and down the street a multitude of times. He, of course, made the connection that they were casing and attempting to rob that store. He used his background knowledge and training to then detain those individuals, and then he frisked them for weapons and did find weapons. Now, specifically in that ruling, a couple key facts were found, and the decision, again, is pretty restrictive in terms of what it meant law enforcement can do. Number 1, it clarified that a frisk as well as a detainment does classify as a seizure. Number 2, it deemed that law enforcement can frisk individuals if they have reasonable suspicion to believe that there is a safety risk. 3, allows them to frisk without a search warrant based on their specific observations. Specifically, it was quoted in the ruling that is the on-the-spot observations of the officer. Number 4, it is the officer's observations that must be taken in the course of their investigation. That an officer, when they are investigating something, witness these specific acts that seem to allude to criminal activity taking place. Now, overall, how this relates to this case, first and foremost, is that officers did not witness anything. Now, as I mentioned, of course, in the facts of the case, the officers received a 911 call. They didn't go to the scene and see an individual with a Class 3. They didn't hear any gunshots. They didn't in any sort of way perceive of their own senses criminal activity that was taking place. When they arrived on the scene, they saw a group of 6 individuals standing in a circle on an apartment building. They saw the defendant on his phone. It was even testified to in the trial from Officer Ross that there was no suspicious behavior that they saw. Now, specifically when it comes to Terry and the application of Terry, the officer must witness the behavior that is deemed to be suspicious or related to criminal activity taking place. Now, in this case, that is not what happened. The officers didn't witness anything, nor did they perceive anything. They solely relied on the 911 call that they received. Now, again, specifically in Terry, the officers must be the witness. They can't rely on anyone else. And that's, of course, can be deemed enough evidence to justify a frisk of another individual. Whether or not other case law ruled a different way, that, of course, can't be considered. When we're solely basing the case law, in this case on Terry, must solely...
Yes, dear, you said that.
Yes. And was solely related as to what Terry found. Now, when it comes to the vagueness of the 911 call, again, I alluded to this a little bit in the respondent's brief. But overall, the 911 call in and of itself was far too vague. Now, of course, we could go back and forth all day, but specifically, the 911 call was a single call. There were no suspects that were described. The scene was described in the 911 call. There was no emergency that was described. There was no name left or contact details left by the caller. There was no information that would lend to the credibility of the call. And that call alone is not enough to establish reasonable suspicion, especially under the laws and case laws that have been accepted in this state. Specifically, an officer would need to observe the finding of the call in order to deem it enough. Now, again, this was alluded to a little bit in the appellant's response in trial to date. But again, when it comes to an officer making the determination that there's enough evidence to frisk another individual, they need to have the proper background knowledge, training, and experience. Now, the key part that was missing and that was not actually testified to in trial is whether or not all of the officers that testified in trial and performed the frisk, performed the detainment, whether or not they had the background knowledge, training, and experience to determine whether or not the 911 call they received, whether or not it would actually be related to, possible safety, whether or not there could be a class 3 found or another firearm or weapon found on any individual on scene. That was not presented to the trial court. And again, that lends to why the trial court ruled the way they did. Overall, if it's not established in the actual trial that the officers do have that experience, knowledge, and training, they can't find that as a fact. And they can't, in turn, use it to establish whether or not there was enough to maintain the frisk that occurred. Overall, it is the prosecutor that must prove beyond a reasonable doubt every element and claim that they make in the trial. And specifically, when it comes to showing that the officers had enough background knowledge, training, and experience, they did not do that in the original trial. Because they didn't do that, because they did not prove it beyond a reasonable doubt, the trial court did what was right and found the defendant not guilty. Now, for the final point in claim as far as the 911 call and the application of Terry is the presence of an investigation. Specifically, Terry requires that an investigation be taking place and that an officer make observations from that investigation to actually perform a frisk and subsequent detainment. In the trial, no officer ever testified as to an investigation that they performed. They never said that they took photos, collected evidence, found signs of guns, gun usage, the presence of a firearm on scene. They never stated that they saw the defendant or anyone else fleeing from the scene. They never asked anyone if they had a firearm on them, whether or not they were a convicted violent felon, whether or not they had a gun license. They never asked the questions or observed anything that would be relative to an investigation. And because they did not conduct an investigation, they were missing a crucial part of what needs to be attained for Terry v. Ohio. And overall, when it comes to a frisk that is performed under Terry, which is what this frisk was, it was mentioned multiple times by the prosecutor in the trial multiple questions that were alluded to that fact from the witnesses in the trial, that this was a frisk that was performed under Terry v. Ohio. It wasn't performed under any other case law, specifically Terry, that they performed the detainment and frisk of the defendant. And specifically under Terry, a frisk cannot be performed unless it is the basis from an investigation or observations. Officers cannot go out there and say that there is a safety risk and then frisk an individual to specifically obtain other information for their investigation. Terry is specifically meant to protect officers and other individuals on scene. It is not meant for officers to use it as an investigation tool, for officers to detain individuals and frisk them to find evidence. It is only meant to ensure the safety of those that are on scene. Nothing more, nothing less. It's not meant for officers to perform, say, a traffic stop or walk up to a scene and determine reasonable suspicion and then frisk the individual to find evidence. And it's only to ensure the safety of those officers. And what was testified to in the trial was that the officers, they didn't think there was a safety risk. They did it in order to investigate the scene, to acquire evidence, which again is not what it is for.
Peter, didn't you just say there was no investigation?
Exactly right. I may have misspoke in terms of saying there was an investigation, but specifically the officers on scene, they used Terry to try and find evidence. They didn't use it to establish whether or not there was a safety risk. And that's the main point I was trying to make. I apologize if that was confusing at all.
Okay, dear, you may continue. Thank you.
Of course. I'd like to sort of go over what the prosecutor said. Apologies, the appellant said in their response to the court. Now, the appellant brought up the argument that if this case were to be affirmed, that no 911 call could ever be used in the future. And that is squarely incorrect. Overall, there is much more to this case than whether or not this 911 call was enough for this frisk to be performed. This case is more about whether or not there was enough evidence to actually perform the frisk, and whether or not that frisk was lawful based on a number of other factors. Specifically, a 911 call, if that 911 call is credible, can be used as a determining factor as far as reasonable suspicion in performing a detainment. So it is not all that the appellant claims it to be. If this court were to affirm the trial court's ruling, it would not wipe out all 911 calls. 911 calls would continue as they always do. A helpful tool when they are credible, and a tool for officers to gather information if they are uncredible. Now, the appellant also alluded to whether or not there would be probable cause. The trial court's ruling in terms of what probable cause would be and wouldn't be. And the respondent would agree that overall, if an officer had witnessed an individual on scene with a Class 3 firearm, that would be probable cause. However, the key factor is missed by the appellant is that it doesn't need to, in order to establish reasonable suspicion, I think the trial court alluded to this in their verdict. Overall, it doesn't need to be the officer witnesses enough evidence to establish probable cause or gathers enough evidence to establish probable cause. The officer just needs to make some sort of observation that they connect with their background knowledge, training, and experience to then use to justify a frisk, detainment, and ascertain reasonable suspicion. Now, in this case, and the trial court ruled, is not what the appellate is actually looking for. As far as an officer witnessing someone with a Class 3, that would be probable cause. However, there were multiple other issues, a lack of evidence in determining reasonable suspicion in this case. Now, finally,
Your time is up, dear. Do a 2-sentence recap.
okay. Finally, the last point I would like to make is that overall, in the Department of Justice handbook, the state cannot appeal a not guilty verdict. So I'd like the court to consider that as well in its ruling. Thank you, Honor.
There will be a 5-minute recess, dear. Thank you.
All rise. The Superior Court of the State of San Andreas is back in session. The Honorable Justice Granny Noonan still presiding.
Hello, dearies.
Hello.
Now, we are going to do today a bit different, okay? Now, because I am old and I can get out of breath, I have already rendered my ruling. Mr. McLean has been kind enough to read it for me, dear. Mr. McLean, go ahead, dear.
Yes, Your Honor.
I am on the chair now, dear.
In the San Andreas Superior Court of Appeals in regards to case State of San Andreas versus Michael Francesco, opinion written by Justice Granny Noonan. On October 27th, 2021, a 911 caller reported to the Los Santos Police Department that there was a man with a Class 3 firearm in La Porta. Multiple officers responded to the scene and found 6 individuals, which included the defendant. Officers detained and frisked each individual in the area. Francesco was found with narcotics and a Class 2 illegal firearm and taken into custody. The district court ruled that the 911 caller did not provide enough reasonable suspicion for Francesco to be frisked for weapons. The lower court subsequently found Francesco not guilty on these grounds. The Fourth Amendment permits brief investigative stops when an officer has, quote, particularized an objective basis for suspecting persons of criminal activity, unquote. Reasonable suspicion takes into account the totality of the circumstances, including the content of information possessed by police and its degree of reliability. Even though a, quote, hunch, unquote, is not adequate for reasonable suspicion, the level of suspicion the standard requires is considerably less than proof of wrongdoing by the preponderance of evidence and less than is necessary for probable cause. All investigations, whether they be full-fledged investigations or stops on the street, are all dependent upon the content of information possessed by the police and its degree of reliability. Under appropriate circumstances, an anonymous tip can provide sufficient knowledge and reliability to prove reasonable suspicion to make an investigatory stop. The 911 caller in question was able to articulate the location in which they saw a firearm, the time in which it occurred, and what classification of weapon it fell under. The officers immediately responded to the 911 call and found 6 individuals at the location provided from the call. Had the officers responded sometime later, it would have been unreasonable to verify the caller's claims. Reasonable suspicion does not rule out the possibility of innocence. The notion that the Terry test applies only when an officer must witness the conduct firsthand is rejected. A reasonable officer, when receiving the information gathered from the 911 call, is enough reasonable suspicion that a crime is being committed. The reasonable suspicion portion of the Terry test now being satisfied, and that the crime in question being that of a weapon, a Terry stop was initiated. Francesco and others were frisked accordingly for weapons, and when illegal weapons were found, officers had proper probable cause for arrest.
I will take it from here, dear.
Yes, Your Honor.
This is now reversed and remanded, dear. The district court will re-adjudicate the verdict. It will do so under the lens of knowing that the 911 caller did provide reasonable suspicion for the officers to initiate a Terry stop. The district court will also verify that a fine didn't need to be paid back to the defendant, or if he paid one in the first place, dear. So ordered.
Thank you.
Court is adjourned.
Thank you, Your Honor.